Each day, the European Court of Human Rights in Strasbourg receives individual complaints against states for violations of such human rights as the prohibition of torture, freedom of expression, freedom to practice religion. More than 90% of these complaints are declared inadmissible by the court. Why? Because they fail to meet the admissibility requirements. There is a long list of admissibility requirements, and most human rights literature present admissibility through a checklist and keywords. In this clip, I will simplify some of the core admissibility requirements by exploring three questions. First, who can bring a complaint before the Strasbourg court? Second, against whom can you complain? And third, when can you bring a case before the Strasbourg court? Lastly, I'll show how the European Court of Human Rights decides on admissibility issues. So the first issue, who can bring a complaint before the Strasbourg court? According to the European Convention on Human Rights, any individual, group of individuals, NGOs, and at times companies can bring a complaint before the court. The applicant must prove that she has been a victim of human rights violations. The applicant can be a direct victim. Here the applicant is the person whose rights have been violated. Indirect victim can be a family member who can pursue the claim on behalf of the victim. For example, a parent can bring a complaint on behalf of his children. And potential victim, in cases of indiscriminate mass surveillance, for example, everyone can be a potential victim of such measures. Beware, the application would be declared inadmissible if the applicant complains about these measures in general and fails to show how they violate her fundamental rights. Now, the second question is, against whom can an individual complain at the Strasbourg court? The applicant can submit a complaint to the court against a state party to the European Convention on Human Rights that has violated one of the rights guaranteed under the Convention. A state may violate human rights within its territory or, at times, while acting outside the territory. For illustration, if an individual is held in a detention center run by British troops in Afghanistan, the UK could be responsible for human rights violations in relation to that individual. What matters in such cases is whether the UK troops had control over the individual concerned and not where the location was. The last question is, when can you bring a complaint before the European Court of Human Rights? There are two important aspects to remember. First, you must exhaust domestic remedies. And second, you must submit a complaint before the Strasbourg court within 6 months after exhausting domestic remedies. The exhaustion of domestic remedies requires that the substance of the complaint under the European Convention on Human Rights must be raised in the domestic proceedings first. Why? Because the Strasbourg court is only a supervisory body of last resort, and domestic institutions should first have the opportunity to remedy any wrongdoing of public authorities. Only if domestic remedies are not effective, adequate, sufficient, or available, the applicant may be absolved from the obligation to pursue them. The applicant must file a complaint before the Strasbourg court within 6 months after exhausting domestic remedies. The rule provides that the application should reach the court within 6 months from the day the highest national court has pronounced a judgment with reasons. If there is no remedy where to complain at the national level, the 6 months period runs from the date the applicant was made aware of the alleged convention violation. The 6-month rule is considered of an absolute nature. Only in rare cases of force majeure, the rule may be temporarily suspended. However, be aware that there are situations where human rights violations start at one point, but they never end. In these so-called continuing violations cases, the 6-month rule starts from the day the human rights violation ends. Now, let's look at how the court decides on admissibility cases. Depending on the complexity of the case, the court rules by a single judge. These are most obvious inadmissible cases where the applicant fails to meet the requirements. For illustration, the application was submitted to the court 2 years after exhaustion of local remedies. 3-judge committee, these are the so-called repetitive cases. In other words, the court in its well-established case law has already found such claims to be inadmissible. Chamber of 7 judges. These are not obvious cases of inadmissibility, so the full chamber has to carefully examine the complaint. Lastly, the Grand Chamber of 17 judges. These are the most complex and novel cases that are only exceptionally referred to by the chamber. In such cases, issues of admissibility and merits may be joined. Admissibility decisions cannot be appealed, so the failure to meet admissibility requirements means the end of the case. So now you have a good overview of admissibility requirements. This should help you tackle far more complex admissibility issues in the classroom.